We're talking about default judgments. Kind of the next stage in the procedure is the discovery process, which can take a long time depending on which type of case you have, depending on how many documents the foreclosing attorney has, and usually they have nothing. And then basically with depositions need to be taken. But really the thing that scares the heck out of our clients is a thing called summary judgment. And I want Danielle to elaborate a little bit about the procedure of what a summary judgment is and how do we counteract it.
All right, well basically, and this will be sort of a beginner's guide to summary judgment, but summary judgment, what the standard is, the foreclosing attorney needs to be, they want to be able to get a judgment without actually having to go to trial or prove their case, without having you defend it. So what their standard is, they need to show that there is no genuine issue of material fact. Trying to say that in simple terms, there's just no issue in the documents that are filed with the court. There's no serious issue with what they filed, that we can't contest what they're saying. We're not fighting what they say. There are ways to defeat that, and that's why, again, it's important to have an attorney who knows what they're doing.
Right.
Carmen talked a little bit about the discovery process, but that's one of the best ways to get in there and defend summary judgment. A lot of times, Carmen said these people don't have the documents available. Well, they have some documents. You want to see what they have, and
right.
You, out of those documents, create some kind
Issues
of an
of
issue.
Facts. Sure.
Any issue of fact should be enough. That's the standard. One issue of one genuine issue of material fact is the standard, and it should be able to defeat summary judgment. Summary judgment is very scary.
Yes, it is.
For the clients.
For the attorneys too.
For the
attorneys, very stressful
right,
for us.
Because that could be the final step. If
right.
the judge reviews the case, what you filed, what the bank's attorney has filed, if the judge reviews what is on file and says there's no issue, they grant summary judgment. What will then happen is a sale date will be issued.
Right.
So it is scary, but it is defendable.
Defendable. Yeah.
It is.
It is defendable.
So definitely through the discovery process, what
right.
Carmen talked about, depositions, what are known as interrogatories, requests for production of documents, requests for admissions. That's why it's important to have an attorney familiar with the rules of civil procedure and what is available to them
right.
to defeat summary judgment.
And I think the importance of this is, I don't like to get involved in a mortgage modification before a lawsuit is filed. And the reason why is there's an unfair playing field. And it's not like I'm trying to avoid the homeowners, but you got to remember one thing. You're paying an attorney for his time and his knowledge. I don't have any specific advantages, or our firm doesn't
right.
have any specific advantages before a lawsuit's filed.
Right.
But once they take the step to file the lawsuit, they're subjecting themselves to the rules of evidence, mm-hmm. the rules of procedure, and a judge who's going to answer arguments, listen to arguments, and if they're not playing by the rules, at least we've got some way to hold them to the fire. And that's important.
Right. I mean, going on what you said with the loan modification
yeah.
before, again, I stated the bank's attorney is at a significant advantage if you have no documents and they have them all, mm-hmm. right? So you want to see what they have before
sure.
you go in there and try to modify and make sure that these are the right people that you're dealing with.
Right.
But you are at a significant disadvantage if you do that without having anything available to you.
Or it's not only what they have, but what they don't have.
What they don't have.
And I mean,
right.
a lot of things that the listeners out there know is that there's affidavits or mm-hmm. assignments of missing. The affidavits are not based upon personal knowledge. And there's a whole host of things in the case law from last year that brought these issues up. And again, everybody knows out there, they've heard of robo-signers, and they've heard of the robo-notaries. And they know that there's a lot of, there's a company out there called LPS in Jacksonville that's getting sued by the state of Nevada for document creation. I mean, if you've got an opportunity, mm-hmm. Google LPS versus the state of Nevada or state of Nevada versus LPS and read that complaint. I think we should make it available to our listeners. If you want some good reading, that will, I mean, it's not fiction, it's fact. And you read this thing and you see what happened, it's scary. And then you want to ask yourself one question. How come the state of Florida Attorney General, Pam Bondi, or whatever her name is not getting involved? It's Bondi or Biondi or whatever. She's not involved in this. She fired two of the most important people in her administration that were seeking out foreclosure fraud. And again, there's a ton of information on the webs on the internet about this. I don't know exactly how much of it's true, but even 1% is true. I'm scared for the people of Florida.